Hello friends. You are watching 3AZ Vision, an innovative distance learning channel. It is important to inform our friends that this is the last part of PPRA Rules, where we discuss the remaining important topics of the PPRA Rules. Therefore, it is desired that subscribe our channel, and click on bell icon, that you may not miss any video, to improve your knowledge. In PPRA Rules Part 5, we will discuss about alternative methods of procurements, maintenance of record and freedom of information, redressal of grievances and settlement of disputes, and blacklisting mechanism or process. Alternative methods of procurements. A procuring agency may utilize the following alternative methods of procurement of goods, services, and works. Petty purchases. Petty purchases through quotation. Direct contracting and negotiated tendering. Number 1. Petty purchases. A procuring agency may provide for petty purchases, where the object of the procurement is below the financial limit of 75,000 rupees, and such procurement shall be exempted from the requirements of bidding, or quotation of prices. The procuring agency shall, however, ensure that procurement of petty purchases is in conformity with the principles of procurement. Number 2. Petty purchases through quotation. A procuring agency may provide for petty purchases, through at least 3 quotations, where the cost of the procurement is more than 75,000 rupees, but less than 200,000 rupees, and such procurement shall be exempted from the requirements of bidding procedures. The procuring agency shall, however, ensure that such procurement is in conformity with the principles of procurement. Number 3. Direct contracting. Procuring agency shall only engage in direct contracting if any of the following conditions exist. The procurement concerns the acquisition of spare parts or supplementary services from original manufacturer or supplier when the same are not available from alternative sources. Only one manufacturer or supplier exists for the required procurement, but in such a case, the procuring agency shall specify the appropriate fora which may authorize procurement of proprietary object after due diligence, and where a change of supplier may result in acquisition of material having different technical specifications or characteristics that may cause incompatibility or disproportionate technical difficulties in operation and maintenance, and the contract does not exceed 3 years in duration. Repeat orders not exceeding 15% of the original procurement. In case of an emergency, but the procuring agency shall specify appropriate fora vested with necessary authority to declare an emergency. When the price of goods, services, or works is fixed by the government or any other authority, agency or body under the law, and for purchase of motor vehicle from local original manufacturers or their authorized agents at manufacturer's price. Number 4. Negotiated tendering. A procuring agency may engage in negotiated tendering, with one or more contractors, with or without prior publication of a procurement notification, but this procedure shall only be used when the supplies involved are manufactured purely for the purpose of supporting a specific piece of research or an experiment, a study, or a particular development. For technical or artistic reasons, or for reasons connected with protection of exclusive rights or intellectual property, the supplies may be manufactured or delivered only by a particular supplier. For reasons of extreme urgency, brought about by events unforeseeable by the procuring agency, the time limits laid down for open and limited bidding methods cannot be met. However, the circumstances invoked to justify extreme urgency must not be attributable to the procuring agency, and the provincial cabinet, for reason to be recorded in writing, approves any specific procurement to be made on urgent basis and shall fix the time for such urgency. Unsolicited proposal. In case of unsolicited proposal received for any engineering, procurement, and construction project, involving cost of 1,000 million rupees and above, the procuring agency shall process the proposal to ascertain its viability, and after such process, if the proposal is found viable, the procuring agency shall advertise the proposal for open competition, without disclosing the name of the initiator of unsolicited proposal, shall conduct pre-qualification process, shall exempt the initiator of the unsolicited proposal from the pre-qualification. If no other bidder in response to the advertisement submits bid, the procuring agency may award the contract to the initiator of the proposal. In case of bidding competition, the initiator of the proposal shall be given first right of refusal, if the initiator does not emerge as the lowest bidder, and shall award 5% additional weightage to the initiator of the proposal, from the combined score of technical and financial evaluation. Exemption. Number 1. The government or the board shall not relax application of these rules for procurement of services. Number 2. A procuring agency may directly procure goods from a public sector manufacturing unit on fixed price or negotiated price, where value of procurement does not exceed 1 million rupees. Number 3. Where value of goods exceeds 1 million rupees or in a competitive bidding, the public sector manufacturing unit participating in the bid may, within 3 working days of opening of the bids, match the lowest evaluated bid. Number 4. Public sector manufacturing unit means a manufacturing unit, owned or controlled by the government, federal government, local government, or by an organization which is owned or controlled by any of these governments and enlisted on the website of the authority. On account payments. A procuring agency shall make prompt payments to the contractor against the invoice or running bill, on satisfactory performance within the time given in the conditions of the contract, which shall not exceed 30 days. Commencement of procurement contract. A procurement contract shall come into force where no formal signing of a contract is required, from the date the notice of the acceptance of the bid or purchase order has been given to the bidder, whose bid has been accepted, and such notice of acceptance or purchase order shall be issued within a reasonable time, or where the procuring agency requires signing of a written contract, from the date on which the signatures of both the procuring agency and the successful bidder are affixed to the written contract, and such affixing of signatures shall take place within a reasonable time, and where the coming into force of a contract is contingent upon fulfillment of a certain condition or conditions, the contract shall take effect from the date whereon such fulfillment takes place. Closing of contract. Except for defect liability by the contractor, as specified in the conditions of contract, performance of the contract shall be deemed close on the issue of overall delivery certificate, or taking over certificate, which shall be issued within 30 days, of final taking over of goods, or receiving the deliverables, or completion of works, enabling the contractor to submit final bill. In case of defect liability certificate shall be issued, within 30 days of the expiry of the said period, enabling the contractor to submit the final bill, except for unsettled claims, which shall be settled through resolution of dispute mechanism provided in the contract. Assignment. A procuring agency may assign whole or part of procurement process to another procuring agency, with the consent of that other procuring agency. Maintenance of record and freedom of information. Record of procurement. A procuring agency shall maintain a record of a procurement, along with all associated documents, for a minimum period of 5 years. Such maintenance of record shall be subject to the regulations framed in this regard from time to time. Public access and transparency. As soon as a contract has been awarded, the procuring agency shall make all documents related to the evaluation of the bid and award of contract public. Where the disclosure of any information related to the award of a contract is of proprietary nature, or where the procuring agency is convinced that such disclosure shall be against the public interest, it may withhold only such information from public disclosure, subject to the prior approval of the authority. Redressal of grievances and settlement of disputes. Redressal of grievances by the procuring agency. The procuring agency shall constitute a committee, comprising of odd number of persons, with proper powers and authorizations, to address the complaints of bidders, that may occur prior to the entry into force of the procurement contract. Any bidder feeling aggrieved by any act of the procuring agency, after the submission of his bid may lodge a written complaint concerning his grievances, not later than 10 days, after the announcement of the bid evaluation report. The committee shall investigate, and decide upon the complaint, within 15 days of the receipt of the complaint. Mere fact of lodging of a complaint shall not warrant suspension of the procurement process. Arbitration. After coming into force of the procurement contract, disputes between the parties to the contract shall be settled through mediation or arbitration. The procuring agency shall provide for a method of mediation or arbitration, or both, in the procurement contract. Misprocurement. Any violation of these rules shall be treated as misprocurement. Blacklisting mechanism or process. Number 1. The procuring agency may, on information received from any resource, issue show cause notice to a bidder or contractor. Number 2. The show cause notice shall contain precise allegation against the bidder or contractor, the maximum period for which the procuring agency proposes to debar the bidder or contractor from participating in any public procurement of the procuring agency, and the statement, if needed, about the intention of the procuring agency to make a request to the authority for debarring the bidder or contractor from participating in public procurements of all the procuring agencies. Number 3. The procuring agency shall give minimum of 7 days to the bidder or contractor for submission of written reply of the show cause notice. Number 4. In case the bidder or contractor fails to submit written reply within the requisite time, the procuring agency may issue notice for personal hearing to the bidder or contractor/authorized representative of the bidder or contractor, and the procuring agency shall decide the matter on the basis of available record and personal hearing, if availed. Number 5. In case the bidder or contractor submits written reply of the show cause notice, the procuring agency may decide to file the matter, or direct issuance of a notice to the bidder or contractor for personal hearing. Number 6. The procuring agency shall give minimum of 7 days to the bidder or contractor for appearance before the specified officer of the procuring agency for personal hearing. Number 7. The procuring agency shall decide the matter on the basis of the available record and personal hearing of the bidder or contractor, if availed. Number 8. The procuring agency shall decide the matter within 15 days from the date of personal hearing, unless the personal hearing is adjourned to a next date, and in such an eventuality, the period of personal hearing shall be reckoned from the last date of personal hearing. Number 9. The procuring agency shall communicate to the bidder or contractor the order of debarring the bidder or contractor from participating in any public procurement, with a statement that the bidder or contractor may, within 30 days, prefer a representation against the order before the managing director of the authority. Number 10. The procuring agency shall, as soon as possible, communicate the order of blacklisting to the authority with the request to upload the information on its website. Number 11. If the procuring agency wants the authority to debar the bidder or contractor from participating in any public procurement of all procuring agencies, the procuring agency shall specify reasons for such dispensation. Number 12. The authority shall immediately publish the information and decision of blacklisting on its website. Number 13. In case of request of a procuring agency representation of any aggrieved person, the managing director shall issue a notice for personal hearing to the parties, and call for record of proceedings of blacklisting. The parties may file written statements and documents in support of their contentions. Number 14. In case of representation of any aggrieved person, or procuring agency, the chairperson shall issue a notice, for personal hearing to the parties, and may call, for the record of the proceedings. The parties may file written statements, and documents, in support of their contentions. Number 15. In every order of blacklisting, the procuring agency shall record reasons of blacklisting, and also reasons for short, long or medium period of blacklisting. Number 16. The authority shall upload all the decisions, available with it, on its website. But the name of a bidder or contractor, shall immediately be removed, from the list of blacklisted persons, on expiry of period of blacklisting, or order of the competent authority to that effect, whichever is earlier. Number 17. An effort shall be made, for electronic communication of all the notices, and other documents pursuant to this mechanism or process. Stay in touch with us and keep on watching our videos in the best of your knowledge. Thanks and goodbye.